You talked about in your career as an academic, quote, interviewing justice officials and accused individuals.
Yes.
You didn't mention victims, victims of crime. Have you interviewed them as part of your research?
No, I study the criminal justice system, not rather than what happens with victims.
Under the stewardship of the Liberal Party, Canada has come to many problems. Crime is, of course, one of them, and we have to start to talk about it on this channel. Welcome back to the Canadian Shield. My name is Sterling. We have a lot of things that are broken in this country, and of course we on this channel know that. Like regular viewers of the Canadian Shield don't come here because they think that Canada is working well. We, however, as a result of that, have an opportunity to sort of make cultural adjustments that will be permanent, that will change the direction of our nation, or perhaps solidify the direction that the nation has already come from. Now, many of you in the large metropolitan areas are going to be frustrated and fed up with crime, and of course you are. Lots of that can be attributed to the trend of the far left to say that we don't need any police. And then when they pushed out all of the people that believed in law and order, they hired people who believe in two-tiered policing. And that's something that we have to be talking about, or two-tiered court systems, or two-tiered criminal code. And there's some of that in this upcoming interview, or excuse me, this upcoming presentation. Now, what we need to look at in our culture is what is it that we want to gain? What is it that we want our culture to look like when other people are looking at us? Do we want people to think that we are fair? Do we want people to think we're fair but strict? Do we want people to think we're pushovers? I mean, what are we looking for as a culture? Because we are so broken, we are presented with an opportunity right now to make some adjustments, to make some amendments, to make some corrections. And so we're going to have to be talking about freedom of speech, and we're going to have to be talking about how we deal with crime, which of course is different than what we find criminal. We have to ask ourselves, what is our intention and how do we make our society get away from crime and have rehabilitation, but at the same time, ensure the safety and security of its citizens? So they were talking to some experts in the Public Safety and Security Committee. And we're going to be looking a little bit at that because I think that there's a lot of things inside of the initial interview that we can talk about, or the initial cross-examination that we can look at as a culture to see where the variations and how it becomes so convoluted and how it becomes so polarized. And we need to sort of we have too many polarizing things in this nation. And that's by design by some of the people who are in charge. And it's beholden to us, the people on the ground, to ensure that the people in charge do not manipulate and exploit us through these divisions, through this polarization. Before I get into it, though, I would encourage all of you to double check that you're still subscribed. And I would encourage you to share this channel with all of your socials. Let's check it out. Let's quickly add something before we dive in. The idea of bail is innocent until proven guilty, and I will give you the benefit of the doubt. Because we are looking at a situation where some people are trying to indicate that you shouldn't get bailed depending on what you're charged with, versus people who think you should get bailed no matter what, it's significant to understand that at its baseline, when they devised this system, it was put forward as a innocent until proven guilty, and I will give you the benefit of the doubt, and therefore that benefit meaning that you will return to answer for these charges, to confront and face your accuser. Now, I don't want to give you a crash course in law. I do want you to understand that that's where I work from. I work from this benefit of the doubt, and I have always returned to face my accuser, that kind of thing.
Thank you, witnesses, for your time and testimony today. I'd like to start with you, if I could, Dr. Myers. You mentioned that the bail system is the harshest it's ever been. Those were your words. Do you think bail should be made easier to access after the culmination of our research here?
I think it absolutely needs to be more readily available for a lot of people in custody. I think we can acknowledge that there are some people who are perhaps too risky or the allegations are too serious. We want to focus our attention on those, not an automatic decision to detain, but to be able to focus on those. We need to make release more available for all kinds of others who are there for more minor reasons.
So what are the sorts of offenders that are being detained pre-trial now that you think should be getting bail and aren't and don't have it available to them?
Most of the folks that have been charged with nonviolent offenses.
Okay.
And that would be the bulk of the individuals that go through our bail court.
See, I take issue with that. I'll tell you that people who commit property, because it's a nonviolent offense, is considered to be a property offense for the most part. And when we look at a property offense, we have to ask ourselves, the police actually ask themselves what, the criminal code sets it up in such a way they ask themselves what happened. Did the person bring in an implement? Did the person have a firearm? If you had any of these things, then you can be considered to be a violent act, even though you might never have used it. On the other hand, if you kick the door in or smash the window, which are both causing damage, and then run away, because there was never any confrontation or any implement that was shown or used in the perpetuation of the crime, they consider that to be nonviolent. Now, on the one hand, nothing was broken, and that's considered violent. But on the other hand, property was damaged, and that's considered non. So there's a lot of gray area there. And I think that this individual telling me that there should be separation and segregation based on the idea of what you are charged with, what you are accused of, removes her credibility from me right out of the gate.
You talked about in your career as an academic, quote, interviewing justice officials and accused individuals.
Yes.
You didn't mention victims, victims of crime. Have you interviewed them as part of your research?
No, I study the criminal justice system, not rather than what happens with victims.
So in her mind, the person who is the victim of the crime is not part of the system. Can you imagine in your mind that somebody gave this individual credentials, and in their mind, it is not part of the crime, the victim, whereas the criminal is supposed to getting all of this protection and looked after, the accused, I should change that to, though the individual that had the crime perpetrated against them, well, that's outside of the purview of her study, because in her interpretation, they are not part of the system. Oh yeah, no, that sounds really healthy.
Do you think that the experiences of victims should have any bearing on how offenders are treated by the justice system?
Absolutely. The victims are critically important in all of this, but nonetheless, we need to remember.
So now all of a sudden the victims are critically important. Makes sense. Stick to one position, lady.
The very important constitutional rights that we have, and that those must absolutely be protected. And that while there may be harm to victims, we can provide those supports that they may need outside of the criminal justice system where they would be far better served.
But why
What if the support that they need is knowing that the person that perpetrated the crime against them is not able to walk through society and do it again?
20 years of researching this has interviewing victims not factored in if you think they do have a role to play in the way these decisions are made and these policies are drafted?
Because it has not been part of my research agenda. I've spent the time sitting in court and talking to those who I'm interested in the process of bail. I'm sitting in court. I've heard from many of victims about their experiences that comes out in the open court.
I wouldn't go that far. It's rare that you would bring a victim into a bail hearing. Rare.
So you do indicate that people should, I'm paraphrasing, but you said they should be punished after a conviction. Yeah. So who should be held behind bars pre-trial in your view?
I think a very limited number of people. If we go back 40 years, we used to be sitting much closer to about 20 or 30% of those in our provincial jails were in pretrial detention. I suspect those are the folks that needed to be there, while other folks were able to be better managed in the community.
Do you think that anyone who's charged with first-degree murder should be behind bars pre-trial?
I would leave that to the decision makers to properly examine the information that's been provided to assess the risk and make those decisions.
So you think bail
So on the one hand, she thinks 20 years or 40 years ago, it was all worked out just fine. And then when she's asked if she believes there's a certain crime that should be okay, she says, well, I'll leave it to the experts. so many things in her statement as contradictory. I thought she was the expert, for example.
I think bail for first-degree murders is actually legitimate at times.
I think in some circumstances it could be possible. I'm not a lawyer. I'm not the one making these determinations, and I trust the professionals who have all of the available information to be able to make the appropriate decision in these cases.
Another comment you had made was that we cannot predict future behavior. You were basically you were saying that we can't predict who will commit future offenses. So I would assume from that you're against three strikes, you're outlaws that have been proposed, correct?
Absolutely.
So how many convictions is enough for the system to actually say, we have a pretty good indication this person is going to reoffend?
Well, you know, we might be able to look at measures that indicate that somebody has a record of offending, and those are exactly the kinds of pieces of information that are considered by those who are making bail decisions.
So you do think multiple convictions you do think should actually count against someone in their bail eligibility?
I think it should be a factor that is considered and weighed appropriately. It should not.
See, I disagree. I believe that an individual who has come in for bail one time and then never showed up, or more accurately, because one of the things that you're supposed to remember when you get bail is the first rule is to keep the peace and be of good behavior. Meaning that if you break the law while you're out on bail, you violated your conditions. Therefore, your word, your honor is broken. And you should therefore be punished accordingly. In this example, not being given the benefit of the doubt. Because on the first one, okay, you were given the benefit of the doubt. We said you gave you all these conditions. And the first one meaning that you won't commit any other crime or you won't be accused of committing any other crime while you're out on bail. This is a key component. Now, if you're all of a sudden out on bail and you're getting arrested again, I think that you've already violated your first condition, so why should I give you an additional condition? And I don't see how this expert I don't see how this is an expert at all, actually.
Be the driving and the only reason. Each one of those convictions, that individual's already been punished and held accountable for those offenses. At some point, we have to acknowledge that they have moved on. Let's focus on what the allegations are saying of what they've done now.
So someone who's committed murder against an intimate partner, someone who has robbed a bank, someone who has committed violent offenses. They
Allegedly.
are arrested. No, I'm talking about someone who's convicted. They have 5 convictions under their belt. Your view is that that is a clean slate if they've already served their sentence the next time they're up for bail?
I said nothing about it being a clean slate. I said
You
absolutely
did. You said they've
no.
already paid their price.
They have paid that price, but nonetheless, the criminal record is a critical component that is considered by decision makers when making the evaluation on the level of risk.
See, no, again. Oh, yeah, you can say that if the criminal record says that they have 4 or 5 breach of conditions, which is actually how I think the word the charge. So when you get arrested for violating your probation, you get what's called a breach of conditions, and the same thing holds true for bail. If I remember the wording correctly, now they may have changed the wording since I last took a look at it. Doesn't matter if that's on your record. If you got like 10 or 12 of them on your record, or 1 or 2 of them on your record, then it's obvious to the judge or to the Crown that you're going to probably have a problem violating the bail condition. If you did 20 years but never once violated your bail condition, does that mean that you shouldn't be granted bail? Because I think that that's what we need to be as a culture to be looking at. If you're out on bail and you're breaking the law and then you're getting arrested while you're out on bail, you absolutely should not be given any more bail. That's just my position. But if you're out on bail and you've kept the peace and been of good behavior and made sure you showed up when you were supposed to and all the things like that, and then end up getting sentenced to 5 years, and then in year 6 you get arrested again, and there's no reason for the judge to say, well, this person kept their bail the first time, so they must be willing to do it again the second time.
We cannot perfectly predict. We can make predictions on the basis of offenses or records, but they are imperfect, meaning we are getting it wrong a lot.
Mr. Spratt, you mentioned in your comments that, we have a mechanism already, which is appeal, but there have been numerous instances that people have committed often violent offenses well out on bail. Is the process working? Is the process of letting the Crown appeal if they feel bail is too lenient, is that working?
Yes.
And what would you say needs to change in the bail system? Keeping in mind we have about 30 seconds left here.
Well, I think there's a number of things that need to change. We need to have timely bail hearings. We need to have less volume in bail court, so get rid of some of those low-level property offenses that those people are taking up time that the court can use to consider some of those higher, more serious cases.
See, again, it's the wrong position. These guys are looking at it like they're being sentenced, right? On the one hand, you tell me that they are not convicted, they're just being accused. And so now you want me to believe that the other thing about it is to like, so sorry, I'm saying two things at once here. First, let me establish that if you tell me that a person who's accused of a certain crime versus one who's accused of a different crime, or a third or a fourth or a fifth different crime, they shall all of a sudden be given priority. That's two-tiered system. And I don't have no room in my life for that kind of thing. There's no room in Canada for that kind of thing. Everybody is treated equal under the law, whether it be Mark Carney or whether it be just somebody who's a random individual, no matter how much power or how much influence versus a person who has none of those things. Equality under the law is what separates us from many of the dictatorships of this world. Further, a person who commits a violent crime, though horrendous and all of that stuff, doesn't commit property offenses in anywhere near the volume. A person who is a quote unquote thief will steal a lot of stuff, and they often will come before the judge with 27 charges or whatever. Whereas an individual who commits violence, again, I'm not saying to you that it's good. I'm just saying to you that it's often one or two incidents, and that is the kind of thing that we need to be considered, because there's a lot of there's a lot of property offenses that can happen in the course of even one night. If a person is, like, say, running through all the cars in a parking lot, every one of those is an individual charge. And though you might want to look at it as one evening, it's certainly not going to be one significant impact. When you think about 50 people owning 50 different cars, you've now had impact on 50 different lives. So this idea that it's nonviolent because they didn't confront you, but they smashed all the windows in every car, I don't know that necessarily is my understanding of the definition of the word. Of course, now we were dealing with the left, who thinks words are violence. So it's kind of a gray area. But we need to understand that we have to establish what we're looking for so that we can tell our MPs what it is we want.
And I think that we need to have more access to supports. There's some very good programs in Ottawa, the John Howard Society Bail Program, independent third-party verifications. Things like that can go a long way to mitigating risk and making sure that we're not filling our jails with people who will come out in a worse situation and are legally not guilty until their trial, until they're convicted.
So he says that, which I agree with. The last thing he said there sounded fine. But at the same time, he believes that a person who's accused of something should be given bail hearing over someone who is accused of a different thing should be just given like a revolving door and passed out. Like he doesn't believe that a person accused of a nonviolent crime should have to appeal before the bail hearing. Now, I don't see why bail hearings take so long. Like he says at the beginning of his statement, was that they're getting backlogged. And with today's day and age, like, they should have nothing but a camera set up right there in wherever the prisoner is being held, and a justice of the peace or a judge ready to hear the hearing. Now, I get that could take time, and the judges have to sign a lot of paperwork, and I get all of that stuff. But that's, the kind of situation we need to be looking at addressing, right? Like, perhaps we should be running bail hearings 24 hours a day. If there's such a volume, I get it that people don't want to work nights, but at the same time, there has to be a way that we can figure it out, rather than just say, oh, you've been accused of 75 break-and-enters, but because it's a nonviolent crime, even though you smashed a window in every single solitary episode, you're out the door. And on the other hand, you're accused of punching some random guy in a bar who you probably will never see again, and you're not allowed out. It's like there's a lot of gray area, and we have to remember that for conviction, I understand the difference in being sentenced. But for bail hearing specifically, we have to ask ourselves, why would we treat anybody differently? Because the conditions will not come out in the bail hearing. What we have to see in the bail hearing is, will you return to court, and while you're out, will you not break the law again? I appreciate there are people in this world that got bail and they shouldn't have, and I appreciate that there are people in this world that didn't get bail and they should have, or in Canada. However, from where I sit, we have to make sure that the law does not become a two-tiered system, and we absolutely cannot permit people charged of a certain crime to not have the right to have a bail hearing, unless, of course, that crime is a violation of your bail, right? Like if you've committed a crime against your bail, then that's something that should be held against you as a strike. But the Liberals, they want to let everybody out because they believe that they should, defund the police. And in doing so, they distract the average, everyday, ordinary person. If an individual is more worried about their safety and security walking from their apartment to their metro or to the subway or to the bus stop or something, even just to the parking lot where their car is parked, it's easier to distract them from the fact that the government can't close a deal, or that the government made a bunch of promises they're not keeping, or that the government is spending more money on interest for their deficit spending loans than they are on the hospitals and schools. Those are the kinds of things that we have to see as part of the nefarious intention of these rules. However, if we just push all of that aside and we look at the letter of the law, the spirit of the law, we have to remember that there was a time in our culture, especially, where the king could accuse you of something, or just say, take that person away and throw away the key and put him in, detain that individual, without ever having a charge, without ever having a judge to come in front of, without ever having any rights. And that's something that is happening in many parts of the world today. Many of the people that come here from other countries, that's the kind of thing that they're escaping from. We can't allow that to be the kind of rule of law that Canada has. We can't permit that kind of thing to be running through our society. And I get that it's a very convoluted situation, and I feel that we need to distill it. We just have to boil it down to the idea that if you're accused of a thing, there's not a good idea to be held, unless that thing you're accused of is a violation of the conditions that the courts have set up on you, whether they be probation, whether that be bail. We have to allow that individual to have the benefit of the doubt. Now, if that individual is out on bail and they violate the crime, then that's zero tolerance. If they violate their conditions, then that's zero tolerance. Just like the zero tolerance people give, when they try to cancel somebody. Zero tolerance for the violation, and that's the kind of power and authority that should be given to the judges, not have their hands cuffed by saying you have to make it as easy as possible. Because many of these individuals are going to have to come before this court time and time and time again. So now you want to have 5 or 6 bail orders attached to the individual, because you don't want to say to yourself, they already broke their word to me, so it's now no. I don't believe that that's anything other than a recipe for disaster. But you can let me know what your opinion is down in the comments. I'm going to wrap here. Thank you for listening. I'll talk to you next time.